Okay. This is the ARB work session. I guess we got to go through the regular routines. Let's call it to order. Agenda, please, for roll call.
Corral. Cabrera-Wosick.
Here.
Schneider. Cavazos.
Here.
Larson.
Here.
And there's Schneider. Are you here?
I'm here. Sorry, late getting off with the kids.
You're okay.
Chick-fil-A.
Blame it on the drive-through line, right?
No, they're actually getting out, trying to turn left, come back into town. Who are we missing?
Says Monday night.
Missing
Yeah.
our PC liaison? Yeah. Then who's to your right?
I think it's just the extra paper.
Oh. Oh, my crap over there.
That is a very nice tie.
Thank you, yes.
Are we?
Traditional, original bridge.
Yep, we are live. We're having technical difficulties, so we're waiting for the mic to get up.
Thank you very much. All right, we're live.
All right.
How would you like to proceed, Mr. Chairman?
Okay, well, our primary discussion, it looks like you have a lot of discussion materials. I don't exactly know how you want to present it, so begin.
Well, thank you, Mr. Chairman and members of the ARB. I am Martin Krim, Town Attorney, and I'm here to do a little bit of discussion about the Historic District law and procedure. I was asked to do this, and I'm happy to do this. Very similar to training I did for another ARB a couple months ago. And so the first part, I'm just going to run through real quickly about the bases for what the ARB does and what its restrictions are, and get a little bit into the town code provisions of the substantive nature, and then talk about Robert's Rules of Order, because I was asked specifically to do that, and to talk about that in context of your bylaws that need to be updated. So let me just start and run through these materials as I presented them here. On page 1, I did provide you an excerpt from the Constitution of Virginia that says that General Assembly shall pass no law whereby private property, the right to which is fundamental, shall be damaged or taken except for public use. So all of those words have specific technical meanings in the law, except for fundamental. We really don't know what fundamental right is in this context. It hasn't been construed by any court yet. That, to my knowledge, certainly hasn't been construed by any appellate court that would have precedential value in Virginia. We do know that in general, fundamental laws fundamental rights are more important than non-fundamental rights, but we don't know exactly how that would play out in a situation where some litigant says, I have a fundamental right to property, and therefore the government can't make me do X. But we know it's out there, and we know that certainly that somebody's going to make that argument that it is on a level with core rights like political speech, which is another fundamental right. So I highlight that. The second page I have is the definition of historic area from the Code of Virginia dealing with planning and zoning. There's very little in terms of definitions of historic nature in that code section 15.2-2201. This is the one that really speaks to it. And as you can see, it's very general and vague in terms of definition of historic area. words like notable and significance, and it leaves a lot up to the locality and up to the ARB, in fact, and how it's going to be applied. So we do know that it can be, doesn't have to be recent history. It could be archaeological history. We know that, and it can also be an architectural matter, that rather than being something George Washington slept here kind of thing. I provide those for informational purposes, and then on page 3 we're talking about purpose of zoning ordinances, and I've highlighted number 5 there, to protect against destruction of or encroachment upon historic areas. That's the only mention here in the purposes of zoning ordinances that deals with historic matters. So we are clearly protecting against destruction of or encroachment upon historic areas when we enforce the historic overlay district in the town of Haymarket. So what encroachment means is a good question. We know what destruction means. Encroachment, it seems like to me, is open to a little bit more of interpretation than destruction. And we know that once the historic buildings are gone, they're gone forever. And they may be well documented and you may be able to recreate them, but they're still gone forever. But encroachment, you think about the house in the movie Up with all the big buildings around it, and there's this tiny little bungalow that's still there. Maybe that's what they mean by encroachment, but I've never really seen that interpreted either. And let me just say this, I'm the kind of speaker that I like to have questions, so don't hold your questions to the end. Just zap me with the questions as soon as they come into your mind. And then starting on page 4, I have the historic preservation statute that specifically allows the creation of architectural review boards and provides 2 of the 3 ways for demolition of a historic structure to take place. And this is a statute, like a lot of statutes in the Commonwealth of Virginia, that has grown and changed over the years and has been added to and never really rewritten. It probably needs to be rewritten because it's kind of confusing. So I annotated it for you to an extent. I put creation part 1 there next to subsection A1 so that you can know to go look for creation part 2, which is all the way over on page 6 of your outline, subsection C. They added that a few years ago to make it more difficult to establish or expand a historic district. And so that was a consideration when the town looked at reducing the size of its historic district some time ago. The issue came up, well, if we do that, it's going to be very difficult to reestablish it because of this provision here that requires written criteria, an inventory, and application of the criteria to the inventory of houses, and you have to have at least a majority of the houses meet those new criteria. So that seemed like a lot of hoops to jump through that the town didn't really want to have to deal with. So that's something to bear in mind if the town ever, if you're ever asked about whether the town ought to constrict its historic district boundaries, you might remind people that it's difficult to get back to where you were if you decide that wasn't the right thing to do. I also annotated in subsection A1 there on page 4 of your outline the 1, 2, 3, 4 as the kinds of different things that are guaranteed protection or provided protection under this statute. Historic landmarks is one, and to my mind that is things like the church that survived the burning of the town. Those are things that have really significant historic and architectural meaning. Number 2 is other buildings or structures within the locality having important historic, architectural, archaeological, or cultural interest. In your case, the ordinance provides for anything over 50 years old to fall into that category. And then 3, historic areas, which, as I pointed out, are defined. And then 4, areas of unique architectural value. And those have to be within certain kinds of districts. Conservation, rehabilitation, and redevelopment districts are areas that have been set aside by the locality for special attention because they might need some TLC. So you might think about Carytown in Richmond that had a period of time when it was not being kept up very well, and then now it's very vibrant. So that's the sort of area that you can have under the number 4 that I've added there to you. And then you have the ordinance A and B. I've annotated that, where A is one or more historic districts and B is parcels of land that are significant routes of tourist access. So those are the kinds of things that can be in a district. I also highlighted 3 provisions there about how we go about doing enforcement of the historic district ordinance. One is requiring documentation from applicants who come to the ARB. The second one is to require that no building or structure be erected, reconstructed, altered, or restored unless approved by the review board through a certificate of appropriateness. And then the third is dealing with demolition of historic landmarks, buildings, or structures. You'll notice that there is a difference between the second part that I've highlighted there that says no building or structure, including signs, shall be erected, etc. And then under the third part that I've highlighted, no historic landmark, building, or structure shall be raised. So the requirement for a certificate of appropriateness for building something applies to every structure within the historic district. But the demolition only applies to historic landmarks, buildings, or structures. So if in your case, if I have a building that's under 50 years old, it's not a historic building under your code. Therefore, I don't have to get your COA to demolish it. That's just the property owner's right to demolish anything that's under 50 years old without going through the Architectural Review Board. However, to build something in its place, they're going to have to come to you for that certificate of appropriateness. Okay? So that's an important distinction. There's an appeals process that's provided for there. Don't need to really get into that, except where I've written on page 5 of your outline the word standard of review. That is a critical piece to understand because you're in the position of creating a record, just the way that a lower court does when it creates a record in the trial that is then reviewed by an appellate court. You are creating a record of the reasons for your decision either to grant or deny the certificate of appropriateness, and that becomes the record when it goes up to the town council for review, and it still remains part of the record when it goes up to the circuit court if it does, and further. That's the record of the reasons why a certificate of appropriateness should have been granted or denied, and you have the ability to take the report of staff and say, yes, we like this report and we are adopting it as our own record in this case, or you can say, well, we have additional material that we want to add to the record. We want to say, this is what we found, this is what we investigated and determined ourselves, and therefore we're going to create a bigger record than what the staff provided to us. But whatever you do, that then becomes what the town council is reviewing. You'll note that the appeal process provides for the town council to consult with the ARB. It doesn't say how. It doesn't say how the town council will consult with you. At a very minimum, you have an opportunity when you vote on a certificate of appropriateness to create that record that says this is why we decided this way, and then to that can then become your consultation with the town council about why you made the decision that you did. And then I also highlighted there and annotated demolition method 2. Let's talk about that for a little bit. This doesn't actually involve the ARB. It only involves staff. But you need to understand it because this is the by right demolition that all property owners have the option to take. So they have to apply to the governing body for the right to demolish. And it's not clear in the statute whether that is apply for a certificate of appropriateness or some kind of other application. But typically people apply for the COA because they think they might get it, and that would be quicker than waiting the year to go through method number 2. So then you see that Roman numeral 1 has applied to the governing body, Roman numeral 2, for the period set forth in the schedule below, which is going to be 12 months because it's, the numbers are so low. But it's basically, it's going to be anything that is $90,000 or more is going to take a 12-month marketing period. And then Roman numeral 3, there's been no bona fide contract for the sale of that building and the land pertaining thereto within that time period. However, a couple of caveats there. So in Roman numeral 2, I kind of skipped over the part where we said at a price reasonably related to its fair market value. So how do we determine that? Ultimately, the staff is going to need to determine that that's a fair market value or some number closely related to the fair market value. And to do that, we can use the tax assessment. We could go and get our own assessor, own appraiser. We could ask them to provide us a copy of an appraisal or at least of a broker's opinion. And that's the process that we go through to make sure that they are actually marketing it. And then I didn't highlight this, but the language also is that they were going to sell it to a person, firm, corporation, government, or agency thereof, or political subdivision, which gives reasonable assurance that it is willing to preserve and restore the building or structure. So that's an important caveat, too. They can't just sell it to somebody else who's going to then come in and demolish it. They have to sell it to somebody who says, I will preserve this. And that can be a local government. It could be the town. The town has the ability to buy property for historic preservation. And it's an important thing to bear in mind that it's not just selling the property to somebody. It's you have to market it for preservation. So that's an important thing to bear in mind, because when people come before you and ask for a certificate of appropriateness, you're going to be thinking in the back of your mind, well, look, I'm going to consider this on the merits of whether it should be demolished or not. But I know that the person has the ability, if they say that it's really not salvageable, if that's their basis for saying this property should be demolished, let's test that in the marketplace. See if somebody in 12 months is willing to come by and buy the property at something approaching its fair market value for the purpose of preserving it. Because I've seen that happen where people said, oh, here's my report, the engineer says it's going to cost X hundreds of thousands of dollars to restore this building, but we said, look, we're not going to give you the certificate of appropriateness. You can market it if you want to. And they did, and lo and behold, somebody bought it for preservation. So it can and does happen. I don't take people's word for it when they say that nobody will buy this property. You don't know until you market it. So proof's in the pudding. We've already talked about part 2, the creation method. Let me move on to page 7 here of the outline. This is an excerpt from the building code. I didn't include in the whole section 36-105, just the portion, because it's just too long, dealing with demolition method number 3. So demolition method number 3 is, notwithstanding you don't have a certificate of appropriateness, notwithstanding you haven't marketed the property owner has the right, in fact has a duty to demolish the building if the property maintenance code official determines that it constitutes such a hazard that it shall be raised, demolished, or moved. So that's out of your hands as well. That is, if somebody comes in and says this property is a hazard, it needs to be demolished, then you say, okay, let's get the property maintenance code person in here and have them make a determination for this standard, that such a hazard that it shall be raised, demolished, or moved. Because there are a lot of other things you can do with a building that is a hazard. You can board it up. You can put a fence around it. You can secure the building envelope so that it's not exposed to the elements anymore. There are a lot of things you can do with that, with a building, short of demolishing it. And so let me also say this about the fact that the county now provides your maintenance code official. That's actually a little bit of a benefit to you because it's out of your hands, out of the town's hands. Some third party in a coordinate branch of government, the county, is making that determination. So we're not involved in that process at all. And we might have an opinion, we might provide facts, but we don't have a part of that process. So somebody who's complaining about the town not letting them destroy a building is going to say, well, you have the ability to go to the county. The county's going to make that call. That's out of our hands. So to my mind, that's a positive.
But it's reasonable under that standard. the building official would have to basically say there's no other option, because I know across the street, we put fencing around, we required it to be boarded up.
Yep.
It would have to be the point where it's basically, you touch it, it's gonna fall down on someone. And
Right.
it's probably the litmus test for a building official to say that's the only other option.
Yeah,
Okay.
that's been my experience. If, you
Okay.
know, the building's got a serious lean to it, you know, or the structural walls failing, something.
Falling in or something like that.
Falling in, but, you know, roofs blow off and buildings are still restorable after that, so it depends on, you know, the actual circumstances, and it's gonna be a judgment call on that person's behalf. But any of these methods can occur at any time. A person can come in for a COA and apply for it, and also, you know, start the 12-month clock for marketing the building, and go to the maintenance official and say, I think this building needs to be demolished. All three, in any order, it's the property owner's choice. Okay?
And Mr. Chair, on this point, I think I had particular questions, just want to make sure I understood it. So
Right.
we're kind of at cross purposes right now. I think as a town, we have the ordinance that we have to administer, and then we have the blight ordinance that the town and the council's been aggressively utilizing.
Right.
And so one of the questions I had was kind of the hierarchy. When I read the, the zoning ordinance we have, and this is maybe something we want to address in the guidelines, we have the guidelines that talk about demolition by neglect, and the building official can step in.
But
We have the blight ordinance. When I read through it, the building official can call it a derelict building, but I read it to say that they still needed to file a certificate of appropriateness to raise it.
So there's several different tools in the toolbox.
Okay.
And they all basically stem from nuisance law. The law of nuisances is Old English common law that says that something is a danger to other people. And you can either be a private nuisance, which is a danger to a small group of people, or a public nuisance, which is a danger, as the old case law says, to all the king's subjects. So if something is a danger to all the king's subjects because you've got a house that's built right on the sidewalk and it's about to fall over on people walking on the sidewalk, that's clearly a nuisance. And that's the kind of thing that the state code provides for outside of zoning. It's not a zoning provision. It's elsewhere in Title 15.2 dealing with cities, counties, and towns, but it's not a zoning issue. It is a public health, safety, and welfare issue, yes, just as zoning is, but it is not a zoning issue. And so it is handled by a different set of staff. The process depends on what the circumstances are and what the statutes provide. So there's a general nuisance provision that says if something's a nuisance, the locality can go and abate it. There's a technical term. They're going to go and abate the nuisance by making it safe. So, and there's some case law on this. If the property is a nuisance because the porch is a danger to people, you can't go demolish the whole house. You're just going to knock off the porch, right? So you're just going to take whatever steps are necessary to protect the public safety. There's also a specific statute, 15.2-906, that is reflected in the code section in the town code that Marchant was citing, 21-5.
It's 22-5 or something.
22-5, that deals with, specifically with properties that may create a hazard for the public. So that's another standard entirely. It's all maybe. But you can then go to the property owner and say, come up with a plan for how you're going to address this safety problem. And you have to, you know, do the notice to the property owner, you have to advertise it properly, and you have to, you know, go through the hoops. Those are all tools that are available to the town to address the same sorts of things as our demolition by neglect. However, you know, there are broader tools because they don't apply just to historic district. All your properties are in historic district. But it doesn't apply just to historic structures either. So you could have a building that's under 50 years old, but is still somewhat of a danger to the public. Maybe the roof is falling off or about to blow off in the wind, and you can address it through that. So that these are tools. The toolbox that is pretty large and robust, allows you to address things in a number of different ways.
So kind of walk, if I understood kind of the conversation then. And this is specific to, I guess, what we're getting ready to handle across the street with the properties. We have the 7 structures, all are over 50 years old. Well, I think most of them are over 50 years old. Some are listed specifically as contributing resources. We've issued blight letters on all 7? 5, okay. And the remedy that they've chosen is to board it up. So they've not necessarily requested a determination by the building official. Yeah.
We issued it on the entire property?
Continue the mic.
Yes.
We issued them on the entire property except the two that have active businesses in them, to clarify.
Okay. And that what they've chosen to do on some of them is to board them up, but we haven't had a building official come out and say they're at such a point where they have to be demolished.
The one on the corner and the one behind Big Fred's, we had a fire marshal come out, inspect the property due to active businesses being in them, and they condemned the buildings and restricted access to those businesses so they could no longer operate.
So, but condemnation is different than,
It's a
Requiring
different
it to be
standard
brought-
than saying that it shall be raised, demolished, or moved.
Okay.
When the fire marshal or the building official says this building is unsafe or unfit for human habitation, they placard it. If you go into the building after that, you're committing a trespass, can be arrested.
okay. So at this point, they filed their certificates of appropriateness. That's the tool that they're choosing right now.
Yes.
They have the other option, I guess, to go to the building official if they want to, Prince William County, come out and assess the building and determine where it's such a nuisance, either under the blight ordinance
No, no,
or
just this one.
just
Just that provision in 36-1056
of the
of the Code of Virginia.
Code of Virginia. And that determination, then that kind of moves beyond our ability to require a certificate of appropriateness,
Right.
that is to such a level that it has to come down. Okay.
Right.
In terms of sale, if I understood correctly, that the sale would have to be that it's not enough for that, like that property's been up for sale for years. It would have to be a formal notification of the town, whether it be a certificate of appropriateness or a formal notice to the zoning administrator that I am intending to sell the or I'm intending to, I want to bring these buildings down, but I am choosing my right to do it under the code, and here's how would have to be something that
We
formal?
certainly would hope that people would come to us and say, this is the plan that I'm doing because I'm intending, if I can't get a willing buyer to preserve this property within 12 months, I'm going to come in and demolish it.
Okay,
And so it would certainly be a wise property owner who came and told you about that in advance.
okay,
But I've also had the experience where they just put a sign up in the property and started marketing it, in which case, as I was telling Emily before the meeting started, I send them a letter and I say, you know, I'm helpful that way. It's sort of like Clippy, the animated paperclip from the old Microsoft Word, you know. It looks like you're trying to write a letter. It looks like you're trying to demolish a historic structure. Here's what you need to do. You need to, market it at something approaching the fair market value, and tell us how you got that number. And you're going to have to market it for preservation. And then, you know, we're going to monitor it, see if you actually got any bona fide offers to purchase it. And this is when the clock starts. So these are all things that, you know, the wise property owner will take care of, but not all property owners are wise. And so we step in and say, look, this is what you want to do. Yeah, you have a right to demolish the property if you go through these steps. But we're going to make sure you go through them right, because we don't want to have the argument in 12 months that you didn't list it for the right amount of money. We're going to have that argument now.
okay. But not, I think to date, we've not received any sort of documentation to that effect. So that
Correct.
provision probably is not started yet on the
Well,
property.
yeah, I mean, it would certainly, you can just go and grab the MLS listing and see what it says about what the purpose of the sale is. If it says for redevelopment, then that doesn't sound like they're marketing it for preservation at all.
So this is not so much creating an adversarial role, it's just, again, we have, you know, the public, I mean, like my wife and I are kind of what's the word, where you're opposites? She just assumes bring everything down. So we have a public that generally says we got to do something, and the council has done that. But meeting those goals and obligations versus
Right.
our charge, you know, we just want to make sure that when those meet, which they ultimately are meeting now, or getting
Right.
ready to meet now,
Uh-huh.
just making sure that we're all on the same page, as we understand what the tools are.
Right.
So, okay, appreciate that clarification.
Well, sure, and, you know, remembering that the purpose of zoning is like the purpose of every ordinance that the town engages in, which is for the general welfare of the public. And I happen to have a copy of your town charter here, which goes into what the general welfare means for the town of Haymarket. It authorizes the town council to generally to define, prohibit, abate, suppress, and prevent all things detrimental to the health, morals, aesthetics, safety, convenience, and welfare of the inhabitants of the town. So you have the right to consider the aesthetics of the building and on the same level as you're talking about health, safety, and welfare. So you know, and not all jurisdictions, by the way, have aesthetics in their charter. You're one of a handful that I know of. That is an important governmental interest, as declared by the General Assembly in your charter, to protect the aesthetics of the town. But normally, we're talking about health and safety, and commerce and the rest of it, and making sure that, you know, we usually tie things to property values. Why do we preserve historic structures? In part because they preserve the property values of the locality. Okay.
Real quick, as I kind of see the summary, first talking about land rights is simply to let us know that some person can come in and say, I seek that these things you're asking me to do through a certificate of appropriateness is somehow taking my right of way. Just being a heads up that someone may make that claim.
Correct.
Okay. Historic area, I've dealt with this before, where at the time that we created the historic district, it was my understanding that at the time the state code requirements weren't as robust, and that was a concern the last time the town wanted to shrink the historic district, was that you could never expand it again. We would not meet the litmus test. So I understand that explanation in the code and how we established it. So we were legally established, but unlikely to ever be able to expand. And then we just talked through the three demolition methods, although you did suggest that in the one case where someone appeals a COA, that we do be deliberate in how we account for our decision,
Yes.
beyond just kind of the minutes and the discussion.
Right. So, for example, I had an ARB appeal to a city council where there was really very little on the record about why the ARB turned down the COA. And the city council looked at it and said, you might be right, but we can't tell on this record. So they remanded it, which they have the right to do, back to the ARB, and the ARB then came up with a record and said, all right, here are the criteria that set out in the ordinance. This is how we analyze the facts under these criteria. Here's our report. And that was the end of it. It didn't get appealed back up again. But that's what they should have done in the first place, is to create that kind of record as to why they ran through the criteria, just as you have criteria that are listed in your ordinance. On page 10 of my outline, 58-14.9, you've got 8 criteria. Number 8 has 8 subparts, so 15 criteria total. You would do a report that says we analyzed all these things, and this is what we came up with on the certificate of appropriateness. Now, for buildings to be raised, number 6 is clearly the one that's most critical there. The rest of them are really talking about construction or rehabilitation of buildings. But you would want to tie back in your decision to the criteria that are set out in that ordinance.
And I guess we'll talk later about the relationship to the guidelines, I guess.
Yeah, okay. I'm happy to do that. Let me.
Thank you, Mr. Chairman.
So I've included on pages 8 through 15 of your outline here all the provisions of the current town code that deal with the ARB. And so they're in a couple of different articles. There's one section in infrastructure, a couple of sections in landscaping, a bunch of things in signs. And so I've just laid them out there for your convenience and reference. I'm not going to run through those for you. I also included some parts about Robert's Rules of Order, so I'm going to pivot and talk about procedural matters, because you have bylaws that were drafted in 2012. We don't have an executed copy of them, so we don't think that they were actually ever adopted. But you do need to adopt some rules of order, because the ordinance does say that the ARB shall adopt parliamentary procedure rules. So why do we have parliamentary law? I included an excerpt from RONR, stands for Robert's Rules of Order Newly Revised, which is the official abbreviation for Robert's Rules. The current edition is the 11th edition, and the pages 51 to 52, and talks about, why do we have these rules, and they've been in existence now 150 years or so. And they've been wildly popular in America and around the world because they're adaptable to all kinds of different societies. Churches, fraternal organizations, lots of different groups have used Robert's Rules of Order, and it's been found because they are adaptable to all kinds of circumstances, where everybody is just all in agreement and everybody's civil and can get along. They work great, but they also work great when there are people that are butting heads and not being as sweet as they could be. So what are the principles? The principle is that there's majority rule. The majority makes a decision. Obviously, though, you want to make sure that the majority has heard all of the important facts and arguments that they should hear before they make a decision, and therefore the right to debate is preserved. There is a right of every individual to voice their concerns, generally speaking. Now, the majority, a two-thirds majority, can say we're tired of debating this, and we're going to call the question. That is something that you see a lot in organizations where somebody just says, call the question. And that's not how it's done. It's a motion to terminate debate. It requires a second. It requires a two-thirds vote to terminate debate. And if it doesn't get a two-thirds vote to terminate debate, then you go on debating. That's important. That's one parliamentary procedure I've seen misused probably more than any other is calling the question. But the purpose of that is to preserve the right of the minority to be heard, particularly if there's more than a third of the people who still want to talk about this issue. They think they might still change some minds, or they just have something they need to get off their chest. They still have the right to do that. Individual members have a right to voice their opinion, and they're encouraged to do so. I mean, that's why you're there. The right of absentees, so people who are not present at the meeting still have a right. Most importantly, when it comes to amending bylaws, if you have a bylaw amendment that's being proposed, you're required to provide that in advance to the other members of the organization so that they can decide, I don't really care, I'm not going to go to the meeting, or, now this is important, I want to be there for that vote. But you can't, at the meeting itself, say, well, I have another bylaw amendment that I want to propose now that I didn't send out previously with notice, because that's not fair to the absentees. It's not fair to the people who didn't come because they decided that wasn't what they wanted to do that evening. So all of these things then have to be meshed together and balanced to get Robert's Rules of Order. And that once you understand that, it starts to make sense. The rules about amending motions and so on and so forth start to make sense because you are talking about getting the sense of the majority while allowing every member to have their voice heard. And that's how we get, well, I move that we approve the certificate of appropriateness to demolish with the condition that the property owner provide us with full documentation of the property, including photographs of all the exterior architectural details. That could be a motion. Somebody else says, well, I like your motion, but I want to amend it to require the property owner also to do a Phase 1 archaeological study. Okay? That's an amendment to the motion. Then you would debate whether you want to make that amendment or not. And then once you've made that amendment, you now have a motion that authorizes the demolition with the documentation and the Phase 1 archaeological study. Then you vote on that. So it's just it's a process of editing. It's like editing a document as a group. Have you ever done that? I make a change. Somebody else doesn't like it. They undo my edit, and I want to redo the edit. Somebody has to make a decision at some point. And if there's a majority rule principle at play, then the majority is going to make a decision about what the final document is going to look like that you're going to vote on. Okay?
Yeah, I'm used to opening discussion after a move and a second. How do you open discussion on a subject before there's any type of movement or does?
Well, Robert's Rules of Order has some stuff to say about that. In the early matter of the 11th edition, there's some discussion about small bodies, small boards and committees. They have the ability to discuss matters without a motion pending. And so if nobody objects and says, our bylaws require us to have a motion before we can have discussion, then you just have that discussion. And that's a good way to get the sense of the group. I mean, the council does this all the time. Yeah, there may be a recommendation from staff, and there's even a draft motion in the agenda, but we have a discussion about it before somebody makes the motion. It's not a problem. If you want to be formal, then you say, we've heard from the applicant, would somebody like to make a motion, and then we can debate it and move on from there. That's the formal way to handle that. And really, though, that's set up for really large bodies. You know, if you get together with 700 of your closest friends, it's not really going to be helpful to have a debate before somebody makes a motion, because you don't really know what you're talking about yet. You often don't have a recommendation. You often don't have a sense of what the options are. So with large bodies, and in fact, that was the rule in Parliament in the Middle Ages and up to the early modern period, was they didn't have motions and seconds, and what happened was you had a bunch of free-flowing debate, and it was the job of the speaker to make sense of it all and kind of write down what it was that the whole Parliament had decided. That turned out to be a crazy way to do business if you're as large as the British Parliament, and they came up with a better system, which was you have to make a motion, it has to be seconded, and you have to have debate, and then you vote. Now, let me say something about seconds, because people get wrapped around the axle about a second. If nobody makes a second to a motion and debate starts or a vote starts, the fact that it wasn't seconded is irrelevant. The purpose of a second is to make sure that this is something that the body wants to discuss. If they started discussing it, they obviously wanted to discuss it. If they voted on it, they obviously wanted to discuss and wanted to take action on it. So the lack of a second is irrelevant once debate started or a vote has started to occur.
Okay, so the distinction is, but on a vote, you would need a second. Or did you just, so we have a motion, we have a motion on the table to approve.
A motion to approve, and any debate, and nobody looks around, nobody says anything. All right, let's take a roll call vote, and somebody starts to, you call the roll, and you take the vote. At that point, the lack of a second for the motion is irrelevant.
Okay. In terms, I guess your point earlier about discussion, so the applicant presents, staff presents.
Right.
We just do go through a Q&A.
You know
That's
what
fine.
you know what the universe of possible options are.
Yeah.
Basically, you
Yeah.
can grant, deny, or grant with the conditions.
Okay. But us having a discussion or asking questions before we take a formal vote, that's still within our purview.
Certainly, absolutely. If you're not ready to make a motion yet, then you can certainly say, this is what I need to know in order to even make a motion here. I need to know X, Y, and Z. Can somebody help me out with that?
And we did have the issue, which I think we got feedback that we handled it correctly, what was the reconsideration?
Right.
I think you reviewed that, and that was correct.
That's correct.
Okay.
Now, I will tell you that last month, Circuit Court in Fairfax decided in a similar situation with the reconsideration by Board of Zoning Appeals, which is very similar in terms of parliamentary procedure for you all. Their parliamentary rules said that they could only do a motion to reconsider within 7 days. They nevertheless did a motion to reconsider after the 7 days had passed. The court said that is a substantive rule, not a procedural one. A procedural one is like the requirement for a second on a motion. A substantive rule is going to affect people's rights because in that case, the BZA didn't re-advertise the matter. They didn't take action to let people know that they were reconsidering that matter. They just went ahead and did it and then purported to reverse themselves. And the Circuit Court said, no, you can't do that because other people's rights have been affected by that. You ruled, you closed the meeting, you went home. 7 days passed. Under your rules, you can't reconsider after 7 days. People had a right to assume that that decision was final unless appealed. You nevertheless went back and changed it. You don't get to do that. So if you're talking about a motion to reconsider, you all did that properly because it was at the same meeting. If it had been a month later and you'd been outside your 45 days to make a decision, because you only have 45 days to make a decision, then you would have been like the Board of Zoning Appeals in Fairfax and outside your ability to do anything about it. That would be, that's water under the bridge at that point. Okay? Sure. So, most rules are, parliamentary rules are kind of procedural. We're going to start the meeting at 7 o'clock. If it's 7:05, that's not a reason to say that the whole action of the ARB that evening was invalid. You didn't start on time, so what? If you started early, that might be a bit of an issue because of the Freedom of Information Act. But it's not going to be something that's going to affect the validity of the action. The substantive rules may affect the validity of the action, so you have to be really careful about that and so on. Let me run through a couple of things about your draft rules of procedure that I noted, if I might.
This is from before. Do we have them? Do we have copies?
I think it's behind our agenda.
Yeah, I think it is. 2012 draft bylaws. Do they have them? Okay, so let me just talk about them because you don't need to have them in front of you to understand what I'm saying. Parts of the bylaws provide for things that are basically duplicate things that are already in the ordinance. And they don't need to be there, probably shouldn't be there. If they are there and the ordinance gets changed, then they're going to be out of whack, not aligned with the ordinance. So what I would typically recommend is that you just simply reference the town zoning ordinance, and this is where you can go and find who the members are, and that sort of thing, and who fills vacancies, and what the qualifications for membership are. Those are all things set by the ordinance. This body doesn't get to set its own qualifications, doesn't get to set its own size, but it does get to do a number of things that do need to be in the bylaws: the election of the chair, vice chair. One of the things in the draft from 2012 is that one of the appointed ARB members must be a certified architect. Well, that's not consistent with the current code, and it's not something that this body can do anyways to determine the qualifications, because they don't appoint. You don't appoint. The town council appoints the members of the ARB, and they can decide what those qualifications are. So a couple other things in here. It says 3/5 of the members shall constitute a quorum. You don't know that the body's always going to be 5 people, though. If it's expanded to 7 people, then you'd have to have 5 in order to have a quorum under this rule, and I don't recommend that. I think that the quorum requirements needs to be a majority. You have a provision in here about adopting the Code of Ethics from the National Alliance of Preservation Commission's Code of Ethics for commissioners and staff. I don't think you have the authority to do that. Virginia has a Conflict of Interest Act that is exclusive. It is the only Conflict of Interest Act and Ethics Act that's applicable to local governments, except to the extent that it allows specific kinds of local options, like a cap on gifts. If it's allowed by COIA, then you can do it. If it's not allowed by COIA, you can't do it. And then the bylaws, and I don't know that you need to say this, but I just pointed out to you, it says the ARB may view the premises. Page 4, paragraph H. The ARB may, in its discretion, view the premises. It doesn't say whether you're going to do that individually or as a group, and I would just ask you to think about that, because if you go and visit as a group, that is a meeting under FOIA, and you have to advertise it. So just be cautious about that, please. The other things in here, are typical things you find in the bylaw: the meeting agenda, the order of things that you're going to take up. That's a very appropriate thing to have in there. The application procedure, though, Article 4 on page 3, I think that's really a staff matter, because I don't know that 15 days is the right number there. That's really kind of dependent on what staff can do in terms of handling it and turnaround. And with the 45-day clock that you all have for making a determination, I'm not sure that you want to have 15 days prior to the next meeting of the ARB, because that might leave you with only one ARB meeting where you could consider it, and then you're behind the 8 ball. So you might actually prefer if somebody files it 2 days before the ARB meeting, to go ahead and hear it on that ARB meeting that's 2 days after it was filed, with the knowledge that you can then ask questions and put it off to your the second meeting after it was filed, and still be within the 45 days. See what I'm saying? So,
Which section are we referring to about that?
so that is section 4 on Article 4 on page 3.
Oh.
Application procedure, applications B.
Okay, gotcha.
So, and, okay, if I might, if no more questions about that, let me go on and talk a little bit about your current ARB guidelines that were adopted by Town Council. These are a number of years old as well, and 8 years old at this point, and needing some updating. A couple things that I would recommend to you, and I've already had a chance to talk to Emily about these. One is that I didn't see anywhere in there a mention of the fact that the historic character of a building is often about its setting. Where is it located? And if you move that building, it loses some of its historical character. By the fact that you don't say that anywhere in these guidelines, you don't leave yourself an ability to deny a certificate of appropriateness to move a building. Because if the building's the same, and you don't say you care about what site it sits on, you've kind of shot yourself in the foot if that is something you're actually concerned about. Second thing is it doesn't clearly state a period of interest. It has this rolling 50-year look-back period. Everything that's over 50 years old is historic, but it doesn't say the period of interest, and that has a couple of ramifications. One is, if your period of interest is from the Civil War through, say, 1930, then you have a frame of reference to say, when we're looking at approving a certificate of appropriateness for a new building, we kind of like you to look like the other buildings that are from that time period if you're in that area that is the core historic area. So by declaring a period of historic interest, you are able to then have another reference point to back up your certificate of appropriateness as part of your record that you're creating for the town council. If there is an appeal, you are saying, this doesn't look like buildings from 1920s or something like that. It's clearly not from the era. It clearly just doesn't fit with the kind of aesthetic look that we're looking for. This 2010 guideline has a color palette that's no longer manufactured, and it was from one manufacturer alone. My recommendation for you is to adopt a number of color palettes and then say or equivalent, and have a color palette that's available for people to come into Town Hall and look at, because that, more than anything else, frustrates property owners and is litigation bait, because you can probably go into court and say, Judge, I couldn't even buy this paint because it's not made anymore, and this is arbitrary and capricious because they're requiring me to go out and recreate a paint that doesn't exist. So I don't want to be in that position of defending that. And the fourth thing I want to talk about on the guidelines is the materials. There's some references, for example, on page 14 to replacing materials with like materials. So if you remove wood siding, you have to replace it with wood siding. That is appropriate in some circumstances. So if you're talking about historic preservation, if you're talking about a building that is, that is a landmark, and you want it to be preserved the way it was when it was originally built, rather than just look the same, then it makes sense to have that. And the area where this really comes up more than anything else is vinyl windows. Okay, so vinyl windows are a lot cheaper than wood windows. They last longer, and they make some nice vinyl windows now. It used to be vinyl windows were all cheap looking and trashy, but they make some really nice ones. They're manufacturers that say, this is our historic look vinyl window. So you can get materials to put in a house to replace an old deteriorating wood window with a vinyl window, looks the same, unless you are an expert and you can tell me what a munnin is, you can't tell the difference, particularly if you're looking at it from the street. So that's an issue where if you tell people you have to replace with like materials, they're just not going to replace. They're going to leave the old rotten wooden window in there and not replace it. That doesn't benefit anybody. It's not preserving the aesthetics. It's not preserving historic structure. It's just looking bad. So my recommendation to you is to move away from materials unless you're talking about a historic landmark. Now, if a historic church that is wood shingles wants to move to something, to wood shingle roof wants to move to a metal roof or something like that, then then you're talking about really changing the look, and you're talking about changing a historic landmark. But if you're just talking about somebody's house that's 52 years old and they want to replace the wood windows with vinyl windows and they look nice, I think you ought to approve that COA, because otherwise you're going to be in court arguing whether that was an arbitrary and capricious decision. And then the last thing I want to flag in this is the fonts. I don't know what the source for these fonts was, so I can't really say whether they're authentic or not. They don't look that authentic to me, but maybe they are. I think you would want to say two things about that. One is that, in knowing that a lot of sign makers aren't going to necessarily have all of these fonts, you might say or equivalent. I mean, if somebody has something that looks just like a Times New Roman, but it's not technically Times New Roman because that's copyrighted, then why not let them have that? Nobody's going to be able to tell the difference except a real font fanatic. And then the second thing I would say about that is, if you have that period of interest that you've identified, why not say that if you can document a font from that period of interest, then you can use it on your building. So if I've got, if I'm putting together a storefront that looks like a 1920s storefront, and I've got some beautiful old photos that I found on Pinterest that show me what the style of signage was in the 1920s, I can document that this is the font that they used. This is what it looked like. And if it's not on this list, according to the guidelines, I can't do that, even though I've documented it to the period of interest. It seems to me you want to reverse that. You want to make sure that if somebody has done the work to document it to the period of interest, that they can do that. All right, I've talked for about an hour, and you haven't asked me that many questions. Surely you have some more questions.
A lot of discussion about demolition permits lately. Or demolition guidelines, any recommendations or concerns?
Well, each building is unique, and you want to have as clear a record as possible. Sometimes it's not possible to get that much research. Other times it is. There was a demolition permit request that I saw in one place that had said there was no historic value to this building. Somebody went and did the research, found out that it had been built by a Union veteran, and suddenly it had lots of historic interest. I think that says that somebody needs to be doing some research on this property, and the historic preservation community is probably the folks that you need to be stepping up and seeing what they can tell you about the value of the building from a historic standpoint.
The one question that would come up was only allowing demolition to occur in the time of building permit for new construction. Is
Okay. No, that doesn't make any sense at all.
Okay.
Because you have a duty under the demolition by neglect or deterioration by neglect provision to maintain a building. So, but if you give somebody a certificate of appropriateness but delay it until the building permit is issued, then the property owner has to maintain the building that they have the right to demolish. Well, why are they maintaining it if they're just going to demolish it? That doesn't make any sense.
Okay.
So that's not something I would recommend. The other thing about thank you for reminding me, there's some provision in there for one of the conditions for granting a certificate of appropriateness for demolition is to say that you have to put in landscaping. Well, landscaping is already addressed elsewhere in the town code, and unless it's historic landscaping, it doesn't really relate to the historic preservation purpose of the historic overlay district. I mean, the historic overlay district relates to aesthetics, yes, but it's not a general aesthetics ordinance that says you can require people to do things that you think are aesthetically pleasing. It's only if somebody has a property that's never had a formal garden on it, and you want them to put a formal garden on it, that's not historic preservation. That's just, we think this would look nice. So you don't have the ability to do things just because you think they will look nice. You have to relate them back to historic preservation. That's why I talked about conditions of, I like the conditions of requiring phase one archaeological, if that makes sense, if you have a reason to do that. I like the idea about documenting buildings before they're demolished, because that way you you build up a book of information that other developers can use for building new buildings or preserving other old ones that says, okay, look, we're going to take this feature from this old building that sadly had to be demolished, but we are now recreating the front porch the exact way it looked, down to the smallest details. Okay?
When it comes to plantings, though, we can recommend approval of a structure that's going to be built by recommending plantings, or are we totally out of?
You're not in the planning business, no. The plants are covered by the landscaping provisions of the town ordinance and site plan provisions. You could certainly, if somebody wants to come in and say, this is what I'm proposing to do, and I researched what formal gardens look like in the period of interest, and this is the row of boxwoods that people would have, that's great, but it's not really relevant to the structure. First of all, the plantings are a lot more ephemeral than the building is, so you're not going to be guaranteed that those are going to be there. But it's also not really, they don't have to have a building permit to put in the plantings. They just have to have the site plan permission, and that's covered by the rules that are set out in the town code.
For instance, with the Sheets additions of the Tesla charging units, the only way to really come up with an agreeable arrangement is to have some type of shielding of that electrical equipment that was going to be stored there. Our approach, which was agreed upon by the COA applicant, was to do that through vegetational agreement.
Yeah, but you couldn't do something that was contradictory to the site plan ordinance. Yeah, you couldn't put a condition on a certificate of appropriateness that's conflicting with the site plan. So you would want to look at, you could certainly offer your input into what the site plan is going to provide, but it's ultimately going to be a matter for whoever approves site plans to do, say, this is the screening that we approve.
Because site planning is planning commission.
Okay.
It's outside of us.
Right.
So this was outside the planting buffers. It wasn't an alternative to the required landscaping.
Okay.
It was an aesthetic that was done to screen the structure. And we did that with the house.
AT&T.
AT&T.
Right. Okay.
The house had a porch that there was, rather than doing lattice work, we're suggesting either lattice or
Verizon or AT&T?
Verizon. And then the house right across the street, screening the porch. Underneath the porch, you could see underneath, and the suggestion was either a lattice or a, shrubbery to screen that.
Okay.
So, and they seemed agreeable to it.
Yeah, I mean, that's certainly something that people can come and say, yeah, that makes sense from an economic point of view and from their own personal aesthetic point of view, that's something they're willing to do. And there's nothing to stop you from having the back and forth conversation with the applicant about, this is the kind of look that we have, that we want to see. But two things about that. One is it's difficult to know when you're going over the edge into requiring an unconstitutional demand. So for example, if somebody wants to come in and they have an acre of land, and you think they ought to take half of that acre and put screening on it, and that really leaves the remainder of the property unusable to them for the commercial purpose that they have in mind, that's arguably a taking of private property without compensation. So that would be arguably a regulatory taking and therefore unconstitutional, can subject the town to liability. So you have to be real careful about to that extent. And the rule for what is a regulatory taking is literally if it goes too far. Well, you don't know sitting here what a judge down in Richmond is going to say about, a three-judge panel down in Richmond is going to be saying it's too far in 5 years. It's very difficult to know that. So I would urge you to be very cautious with requiring giving up of the use of property or doing things that are really out of proportion to the harm that it created. There's a principle in constitutional law that the government can require property owners to take steps to mitigate the impacts that they are having. I mean, we talk about this all the time in proffers, but it's also the case in conditional use permits and so on and so forth. And the classic situation is where somebody is building a property and it's going to increase traffic, and the local government says, we want you to put in a turn lane. Well, okay. Well, maybe the need for the turn lane already existed, but the government doesn't want to pay for it. They just want the private property owner to pay for that turn lane. That's a taking, because the need for the turn lane already existed, and you're just gouging the property owner to pay for it because the government doesn't want to pay for it. So in the ARB situation, you've got to be very careful that what you're asking them to do is, set out. You can point to something in the guidelines or in the ordinance that requires that, and that it is proportional to the kind of impact that they're having. If they're building a bigger building, maybe they need more landscaping, and you could suggest that as a way to something that they could do to mitigate the impact. But it's not just because you think it looks nice. It should be this tall building is going to have, or this wide building is going to have an impact on the look of the town, and we think it would be softened by some landscaping. That would be the way that I would couch that. Okay.
Martin, in terms of tying to the comprehensive plan, so we looking through tonight, I couldn't necessarily find the reference to say we can establish guidelines, but we have them and we've utilized them. We also have policies in the comprehensive plan that speak to goals and objectives of the town.
Right.
I guess in looking at each of those, they're not necessarily explicit. We do in our guidelines pull from the comprehensive plan. We also refer to the zoning ordinance in our guidelines.
Right.
But we should probably do it conversely in those other two documents.
I agree. There is one reference to the guidelines. It's on page 12 of your outline, part of the sign chart, Article 15, signs, section 58-15.7, E as in Edward, submission requirements for ARB sign guidelines as set forth in the Historic District sign guidelines. That's the only reference there is.
It probably just makes sense we should have it in the old historic overlay
Yes.
at some point. Okay.
Yes, and then you would want to have those guidelines adopted through the formal process, just like a zoning ordinance is. And if you go to that much effort, you might want to just make it part of the ordinance as a whole, because it's going to be difficult to change. So let me say this about that. If you have guidelines that are just adopted by motion of the town council, they're easily modified, but they don't have the same force that they do if they're adopted as a zoning ordinance. So are they, you've got to think about this word guideline typically is not something that's binding. So it's a little bit of a dissonance in that document where it says this has the force of law, but on the other hand, it's called a guideline. So which do you want it to be? Do you want to have some guidelines from which you can depart, but these are helpful for property owners to know what kinds of things the ARB is likely to approve, or do you want to have some hard and fast rules that say this is what has to happen?
So that's the utility of the guidelines, is to provide some examples or some ways to address the criteria.
Right.
Someone says, I see this criteria in the ordinance, how do I meet that? Your guidelines are examples on how to.
Correct. Yeah, and that's why, so there's some value to having the guidelines be more of a dynamic document.
But the council has to adopt that?
They have in the past, yeah,
Okay.
and unless they authorize you to adopt guidelines, then they would need to be adopted by the council.
But the bylaws we can adopt ourselves.
You're required to, in fact, by the ordinance, adopt those. I think it's a good idea for the town council to have those bylaws and approve them, because then you know that there's, that the council has some buy-in on your bylaws, but it doesn't say that you have to do that.
How best do we tie in the comp plan references then to?
Okay, so in terms of that, I've seen it done a couple of different ways. You could do it as simply as just having a reference in the comp plan that the overall look of the town is designed to meet its historic nature, and the ARB or the town council has adopted guidelines and just reference them. But you want to have call out, it seems to me, historic preservation as one of the goals in the comp plan.
Okay. I think we have the basis for that already. I think we do say somewhere in the comp plan that we refer to that we have a historic district overlay and we have standards guidelines.
Okay.
We're okay.
I haven't looked at it recently.
Yeah, I haven't looked at it. So.
Okay.
I'm dominating the conversation here. You guys have any other questions? I had written some notes to myself. We already talked about the elements of the design guidelines. I appreciate your feedback on that. If we were to talk about changing the membership or subject matter expertise, we would need to do that through the ordinance amendment, not the guideline amendment. Okay. I wrote down what sort of appendices should we include. You already referred to the color palette I had written down, and then font size. I'm not sure about font size, where that came from. Maybe we want to revisit some of the appendices that we already have.
Oh, yeah, the other appendix that goes into way more detail than you need to is the paint, how to paint.
How to paint.
You got this whole thing that was adapted from Warrenton that this is, this is the temperature that you should do. This is how many days after it rains you should wait. That sort of thing doesn't need to be in there.
Just kind of a pamphlet, how to be as a resource. Not
Yeah. I mean, these
On
if
shelves?
I have a pamphlet, just have a link.
In defense of the ARB at the time, they did it all themselves, so I think
Oh.
they're doing the best they could at the
That's
time. We are talking about relationship to the comp plan and others. Good examples of design guidelines or best practices. I had a colleague up in Loudon that's referred me to Fraser and Associates. Have you had some good examples of?
Oh, I'm no Fraser and Associates. I do have some good examples. Town of Culpeper has just recently redone theirs. I had a hand in that. I like what they came up with. City of Manassas has had a good handbook for a while. Back in the pre-digital age, they had printed up, and it was a nice little 8.5 by 11 softcover book. Other than that, Town of Occoquan's done some nice work. I'm promoting all my clients, but they're the ones that I'm most familiar with.
I would give a reference to Leesburg.
Yeah, I'm sure they have.
I used to work in Middleburg, but I don't remember them being very robust. Percival, maybe.
Middleburg's a little bit different because they actually have a charter provision that deals with historic district review committee. So they have a little bit more robust powers than just people operating under the.
Oh, that's right. You're the town attorney there. That's right. Congratulations. I guess, do we want to, as a group, kind of refer to those, use those as templates if we want to start? I guess the assumption was we're going to start looking these over and amending them and revising them, the guidelines. Do we want to do some plagiarizing or some reference to some of these other?
That's typically what I do, yeah.
Maybe just mark up what we like and what we don't.
Yes.
Yes, someone else.
Martin, I have a question for you.
Yes, ma'am.
If I were to upload the guidelines document into, say, a Google Drive doc, and I share it with the entire board, are we all able to edit that document and it be okay with FOIA and all of that?
Sure, because somebody who requested it could just request it through your
Okay.
normal process, and you provide that to them as it stands at that particular moment.
Okay. If that's something that the board would like to do, I can set that up so that at any given time, anyone can go through, edit, put their comments in, and we can just keep track changes, and then have a regular work session in which we discuss what work has been done.
And in fact, I think if anybody was all that interested and was not on the ARB, you could provide them a link that doesn't allow them to edit, just allows them to view.
Okay.
I think talking about Fraser and Associates, I was told to go to their website, and they have some example guidelines that they refer to, or work that they did we can go borrow from. What elements should the design guidelines have? What should they not have? I think you covered that briefly in some of your other comments. Certified local government status, have you had much experience with that?
I'm not. It seems like it doesn't really have that much legal impact. It's probably more of a policy decision about whether you want to pursue that and or what kinds of doors that might open for you.
Sorry, CLG status, certified local government status at the state, it qualifies you, I think, for certain grants and those types of things, so.
And one thing that we had been looking into was, we don't qualify to be a Virginia Main Street, but we can be an affiliate, so that's also something we're looking into as getting grant money and help with that type of stuff.
Okay. Well, another thing we talked about in the past too was, or at least I brought up too, is incentives. So if we were to look at, allowing bonus density for rehabilitating historic structures, waiving of site plan, tax relief, all that stuff, that goes through a separate ordinance.
Correct.
That the council would have to adopt. Okay.
Right. That is clearly permitted by the state code, but you have to be real upfront about what exactly you're going to be doing with that, and making sure that you don't have unintended consequences. The other thing about that is, in terms of tax benefits, the local real estate tax is just not enough of an impact on people to have that much effect on. What you can do stuff with is through the city of Manassas, for example, has a facade grant program, and those are encourage people to improve the look of their facades, make some money available for that, and if you want to track what they're doing there, that's often a good use of funds.
Do you have any more questions?
I always have questions, but I'm going to leave the floor.
I don't mind. Ask as many as you have.
So I guess circling back to, again, what's kind of immediately before us next month, your suggestion is refer to the zoning ordinance guidelines for our basis. I guess we could still refer to our guidelines if we need to, and then, relevant policies.
Right.
In terms of order of work, should we focus first on our bylaws and then focus on the guidelines? What should be our priority of work?
Guidelines are older, so I would, if you don't have bylaws, then by default you're operating under Robert's Rules of Order.
Okay, so we do have
So I would concentrate on the guidelines first.
Okay. How did we want to start on the guidelines then? Just Emily's suggestion, put it up, or do we want to come back next month with some examples? Do we want to actually go through the document at a future meeting and just kind of highlight what we want to change or take out, or?
I think we should plan another meeting, and I think we should use those examples that you both mentioned, like look at the town of Occoquans, look at the Fraser and Company. Okay. Maybe we can email those to everybody so they have time to look it over and see like what sections they like how it reads, or if they have anything different than ours. That way we can come back together and kind of put it together, or take things out of ours that we think needs to be taken out or changed.
We would probably want to take out all the zoning ordinance references and refer to it, the ordinance generally and as amended, and not have that in there.
Right.
Okay.
Stuff like 45 days, do we want to, 45 days would be a procedural in the zoning ordinance, not in the
That's in the
guidelines.
zoning ordinance, right.
Okay, well, that's discussion for another time, but I guess the focus would be on.
I was going to say, do you want me to start working on a red line copy of the guidelines, and then maybe this next month, you guys can review the ones, as Bond mentioned, Occoquan, the Fraser and Associates, and then we can come together over a version that I've looked at of ours, and then what you guys like in the other ones, and
That'd be great.
start where we maybe start bringing them back together.
That'd be great.
Okay.
Thank you. Yeah, I have written down Culpeper, Manassas, Occoquan, Fraser and Associates. I've also written down Leesburg and Percival, maybe. So that's a lot. Sorry.
I will look into all those and send you guys a link and or download the documents and send them to you so you guys can just start looking at them. You don't have to go search for them.
Thank you.
Great.
Okay, yeah, that's good.
All right. Well, thank you very much for your attention.
Well,
Thank you, Martin.
thanks for putting together this document for us and the research you put into it.
Yes, sir.
Yes, thank you.
My pleasure.
It's very helpful.
Okay. And if you have any other questions, just route them through the business manager or the mayor or vice mayor and take care of them from there.
Wonderful.
Okay?
Okay.
Thank you.
Thank you.
Thank you.
Well, that pretty much does it for our agenda items.
One additional thing I had to add. When we look at this, why don't we specifically also look at page 26, Appendix D, our historic structures list? I don't know how you guys feel about it, but I liked Martin's idea of doing historic landmarks. But also, I think as part of our appendix, if we're gonna have some of these listed as historic structures, maybe we can add the reasoning or some notes on the side. I know some of them have been torn down. I think maybe we also go in and have, as part of the notes, this used to once sit here but has since been demolished, or, the reasoning, maybe it caught fire. I think one, maybe on Fayette Street, caught fire and burned down. So, I think that would be a really good place also to work on, then get it on our website. When people ask, well, why is it historic, we can refer back to a certain reasoning.
And you and I talked about it earlier, I thought it was a great idea, is we have kind of the walking tour pamphlet we did during the last summer, but really doing a better job of highlighting those that have been successful and marketing. I think in Haymarket Lifestyle, for a while, we had write-ups on a lot of the buildings in town and gave people an appreciation when they drove by it.
Yeah, I think maybe Danielle did some
Yep.
of those. I think I found some of them, and we certainly want to get those up on the website at least, so when people go and they look at the Architectural Review Board or the history of town, they can see, and they could print that off, read about it, walk the town and see those structures and how they're being reused, or maybe they were just redone and a family still lives in them, so.
And it tells, 'cause to your point, it tells the story, it tells I think once people realize that and they drive by, they tell the story about it. Hey, I read about that house is, now all of a sudden they're paying attention, not, it's a little derelict. Did have a follow-up question. So Martin, in establishing historic districts, yeah, I think it's a great idea, Emily, on revisiting this inventory. And looking at the period section too, what are we really trying to do? 50 years old, people always argue just because it's 50 years old, preserving because it's old, not because it's significant. It becomes a subjective matter. In establishing the ordinance, we talk about the cultural interest. Can you argue it's not so much, I've heard the defense of the historic district, it's not so much the individual structures themselves, it's the collection. I think you're talking about that context.
That's true.
So you can make some argument that the collective is just as important perhaps as the individual structures. Does that make sense what I'm saying?
Right, so you're saying that by having a critical mass of historic structures, you create the sense of a historic area.
Yes, so that is sort of, you can make some instances those arguments, I guess,
Yes.
if you're evaluating
Right,
applications.
and that dovetails into your certificate of appropriateness analysis, which says that for demolition, if you were going to demolish this building, it would be like cutting out one tooth in your bottom jaw, and it's going to look, it's never going to look the same.
Okay, thank you. Thanks, Emma.
Hey,
That's all I have.
anything else on the board?
Do do you guys want to set another work session date? I know it might be a little far out, thinking about January already, but the rest of December is a little booked for our other two meetings and planning commission, so I think it'll have to be January.
We probably want to stay away from the first week of January.
Yeah.
Is our ARB date the 16th, Emily, on the?
Yes, and I don't know how you guys feel, but I like having a night just set aside for just this, where we don't have to rush 1 hour, get everything packed in, and then to our next meeting, if that works for you guys. Do the separate meeting so we have plenty of time.
What day is town council in January? Is it the 7th? Okay.
On me.
Unfortunately, the 9th, I have a board public hearing.
We could look at,
What about the 14th? Oh, okay.
oh, no,
No, no, no,
the
no,
21st.
actually,
The 14th is open,
Okay, I'm
or,
available the 14th.
or even the 15th. I don't know if Tuesdays or Thursdays.
15th is bad for me.
How does the 14th work for you guys?
I'm available.
That should be good.
I might be traveling to Puerto Rico anytime,
That sounds fun.
December 31st and the end of January. So
Okay.
whatever dates you put on, that's fine, I will let you know.
Okay.
Okay.
For these work sessions, I get up pretty early in the mornings, so I cannot stay late. And we are running like 3 sessions per month.
Yeah.
I do drive in a hazardous area. I do need to be awake. So if we move the work sessions earlier than 7 p.m., I would really appreciate it.
Staff's good, I think, with any time. Yeah,
This
next
is not
week
for always,
Yeah.
but it's
Usually they
it's
are
becoming more common that, the later, and I just, it would be regrettable for me, to start at 8 and, 10.
Would 6 p.m. or 5 work on the 14th? I don't know what everyone's.
I think
Ayush.
Ayush was saying that he couldn't get here any earlier than 7, but we just have to check in with him. Maybe it's on a case-by-case basis.
Yes, case-by-case basis, but I'm just stating the need of
I can
preparation and sleep.
I can coordinate with Ayush. I know for next week he said he was able to make it at 6, so
Okay.
maybe if we give him enough notice,
Okay.
or certain dates he didn't have, I think it was night meetings he had at work or something like that.
I can make an earlier time if we gotta make it work. That's fine.
If you guys want to give me a suggested date and time, I can email Ayush and see how that works.
I think they wanted the January
14.
14.
14th at 6?
14th at 6?
Monday.
ARB work session on guidelines, okay.
Are we going to work these guidelines by subjects or blockages or the whole shebang?
What would you think, Emily? How do you want to attack it?
Well,
Well, being that the actual guidelines are only 16 pages, why don't we,
16 pages, but different subjects, right?
yes, so why don't we start with, I'm trying to look at the table of contents and see. Well, do you have a recommendation of, should we do it section by section, or just look at it holistically and then go from there?
I would say, so, I would think you would want to look at it first from the high level of which sections you absolutely need to keep here, and if something is just duplicative of the ordinance, that's easy to cut. And then I think you would want to look at updating some things that might be out of date, and then you would want to look at the appendices as to how you're going to do that as kind of one block. And then the remainder of it, the meat of the matter, I think you would want to look at that somewhat holistically, because it's all interconnected there. And that's, so, you could certainly take it section by section, but then you might have to go back and revisit some earlier sections if you make a change in one later that says, well, that's not consistent with what we did before, and let's go back and fix that, make it consistent. So, I mean, there's no, I guess what I'm saying is, you've got cutting of things that you don't need to have in there. You've got the appendices that you kind of want to look at as to how you want to handle that. Is that just a bunch of links, or is that still some documents? And then the meat of it, which is really going to be talking about these are the sorts of things that we want to do.
I think we should start with that approach. If that works for everyone.
Are you comfortable in maybe that first blush, what he just said?
Yes.
Redlining a lot of that high-level stuff, and then we can focus in on the, okay.
Yeah, I will start working on that and go ahead and send that over to you guys the first week of January, so that gives you ample time to look at that and review that. And then I plan tomorrow to send you the links of the 6 jurisdictions.
Okay.
So that gives you about a month to review those. Sound good?
Thank you.
Okay.
Just what you want to do over the holiday season.
Good call in January. Thanks. Shelley, did you want to talk about your party?
Okay.
Okay.
Okay, I guess we're prepared for our next meeting. We're all set to call this an adjournment.
Except one last comment. I'm going to send out the agenda tomorrow for the 11th meeting. If you guys have questions, please let me know. Review the documents, and I'm happy to assist, research, answer anything that you have questions about.
Okay. Do I propose we adjourn? All in
Second.
favor, say aye.
Aye.
I think Ken motioned and Marchant seconded.
Yeah.